We know that one of the fundamental cornerstones of the Constitution is the notion of the separation between religion and state. This really emerges from the Bill of Rights, which states explicitly that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Thomas Jefferson, in a letter to the Danbury Baptist Association in 1802, referred to this as building a wall of separation between church and state. There actually is a little bit of a dispute, despite the fact that Thomas Jefferson was a drafter of the Constitution and also, as we know, the person who wrote the Declaration of Independence. But there is a dispute up until contemporary times in America as to whether his description of a wall of separation between church and state is considered to be binding constitutional jurisprudence, or whether this was a personal opinion that is not really binding upon any other legal authority. John F. Kennedy, in a famous speech that he gave in 1960, in front of the, I believe, Baptist Ministerial Association, John F. Kennedy embraced very strongly this notion of separation between church and state as something which is absolute. But as recently as the 2012 presidential campaign, one of the contenders for the Republican nomination said very clearly the opposite of what John F. Kennedy had expressed. He stated, this is Rick Santorum, that I don't believe in an America where the separation of church and state are absolute. And one of the current Supreme Court justices, Antonin Scalia, has made very clear and very prominent his own jurisprudential statements that his belief is there was never intended to be an absolute separation, and while Congress may not favor a particular religion, it is part of the American tradition to favor religion in general over non-religion. This is, of course, very controversial, but it is still a belief that is legitimately held by some who are considered to be among the most eminent jurists in this country. What is the Jewish law approach towards this particular perspective? It's important to analyze, and what we're going to analyze to the best of our ability during the next hour is the internal Jewish law approach towards separation between religion and state, and also the approach that Jewish law has towards the role and relevance of religion from our perspective in terms of how we promote it here within this country, where it is not a Jewish state, but nonetheless it is a state that contains Jews amongst other religions. The essential difference between the American jurisprudence and the Jewish jurisprudence on this subject is that while we do believe in there being a value towards a separation between religion and state, it is not so much to protect the ability of every single individual to practice their own faiths and their own belief system independently, but it is more for the protection of the Torah, the protection of the Jewish law itself. Thus, for example, the king who is entrusted with the guardianship of the people is not allowed to interfere with the internal workings of the Sanhedrin, of the main body of the Jewish judges, in order to ensure that there be absolute integrity in terms of how they conduct their proceedings. That's why the judge, Samuel, who was Shmuel, who was a shofet, who was a judge of the people during the time leading up to the First Temple period, was very upset when the people wanted to appoint a king. And the question is, why was he upset when the Bible says, Som tasim alecha melech, that it is a mitzvah to appoint a king? The reason why Samuel was upset was because the people said, we want a king, L'shavtenu, that the king should be a person who not only leads us in wars, but the king will be somebody who will judge us, who will incorporate his own system of law and therefore overrule the Torah system of law. And Samuel was upset because the king is for the purpose of maybe supplementing Torah law in order to preserve law and order, but the king is not there for the purpose of usurping the system of law that Kadosh Baruch Hu, that Hashem has given us. And in fact, that's one of the reasons why, if you look in the Torah makes it very clear that there is an obligation for the person who serves as the king, who is the premier sovereign power of the Jewish state, to always carry a Sefer Torah, always carry a Torah scroll around with him. Why does he have to carry a Torah scroll? To remind himself that he is subordinate to the principles and to the precepts of the Torah, of the written law, and of the oral law as defined by the sages. And the Talmud has a number of accounts which you'll find in the materials, particularly pertaining to a king during the Second Commonwealth, King Yanai, who often came into loggerheads with the sages because of his insistence on trampling this boundary of separation between religion and the need to keep the religious tradition pristine and intact, and on the other hand, his sovereign authority. So therefore, the main emphasis, according to the Jewish tradition, is to maintain the integrity of the Torah, to maintain the integrity of the allegiance of Jewish law, and therefore it's very important for the sovereign not to be able to trample unduly upon that territory.
So I want to pick up on the experience, as if it were, of the living as a Jew, as a minority in the diaspora, and to some extent, some of the things I'm going to mention are actually relevant to Jews everywhere, even if they are a majority in their own state and so on. But the three key questions are, what should our attitude be towards the degree of disassociation of the state from religion? Because remember, we have votes, we can lobby, we are not mere subjects. We live in, as it was always characterized by the Lubavitcher Rebbe, Malchus Shel Chesed, a regime of kindness, where we have voice and a power and so on. I believe it was Reb Moshe Feinstein who made the point that it is obligatory for Jews to go vote in all kinds of elections to demonstrate our gratitude to a nation that finally gave us a voice and equal rights with the other inhabitants of this country. That being said, the Torah does not stop at the doorstep of our house. And the Torah does not stop with the Jewish people. In other words, we have obligations not just with regards to benefiting our fellow Jews, but obligations regarding society as a whole. And we also have obligations vis-a-vis the type of society that we seek to participate in forming. And in that context, we'll talk about them more later, but there's a fundamental idea that the Torah was given to all of humanity, and there's an earlier set of laws that were given to Adam and subsequently to Noah, called the Noahide laws, which represent a set of fundamental principles of human decency. And those laws were reiterated to Moses at Sinai, and as we shall see later, they became incumbent upon the Jewish people to spread those values to the extent that it is possible to do so. The reason most of us have not heard a great deal about this issue is because Jews voicing their sense of what other people ought to do in society, let alone something that relates to the relationship between God and those people, was fraught with absolute danger to life until until the emergence of the various democracies in which the Jewish people have had a far greater sense of freedom. But I should also point out that the idea that all morality ultimately has to come from God, the basic idea of the Noahide laws is that there can be no morality without God. Without an absolute standard, there only is human belief, and one human belief cannot be proven to be better than another. You can discover whether a mathematical problem is correct or incorrect. But the question of morality and ethics, you either need an absolute standard or one can justify anything, as we have seen time and time again. And the idea of a universal set of laws given by God to all of humanity that the Jewish people are entrusted in, well, the events of the last few months have demonstrated to us that religion alone is no salvation, because one can espouse a religion that teaches the most horrific and murderous activities. And to the extent that we can get these universal ideas that we understand God to have given to all of humanity out there, we have an obligation to do so. That being said, there is another idea that we find very strongly in Jewish sources. We find it as early as the Meiri, Reb Nachum Meiri, who talks about the difference between paganism and the monotheistic religions with which he was associated. Even though Islam and Christianity were not terribly friendly to Jews, to say the least, he sees them in several places as superior to paganism. And by the same token, Maimonides makes such an allusion, but more importantly, there is a strong sense within Jewish tradition that any religion, however distorted, is on the whole, with perhaps some exceptions, one of which we may be seeing today, is far superior. Having some religious belief is far superior to none at all, because the sense that one has an obligation to a greater power and that we don't get to invent our own moralities and our own ethics and our own rules, that is fundamental to any decency. And I would like just to share something that lies at the root of the Constitution, the United States Constitution. And this is James Madison's Memorial and Remonstrance from 1785, which lies at the root of what most of the Founding Fathers, with the exception of Jefferson and some others, thought about the purpose of freedom of religion. I must tell you that this is taken almost verbatim from Locke, who talked about these ideas more than 100 years before. But here's the reason for religious freedom. The religion, then, of every man must be left to the conviction and conscience of every man, and it's the right of every man to exercise it that as these may dictate. Why is this so important? It's an unalienable right, also because where there's a right towards men, it's a duty towards the Creator. It's the duty of every man to render to the Creator such homage and such only as he believes to be acceptable to him. This duty is precedent, both in order of time and degree of obligation, to the claims of civil society. And this is fascinating because this is a Jewish idea. Christianity says, render to God what is God and Caesar what is Caesar's. Judaism says there's only God. Caesar also has to obey God. The only morality, ethic, and law is one that reflects the values of obeying God. And this concept that the duty is precedent, both in order and time and degree of obligation, to the claims of civil society. Madison is arguing, quite simply, that because the obligation to obey God is more important, is precedent and more powerful than the obedience to civil society, because it is such an important good, civil society can't tell you how to worship or establish one church, one form of religion over the other. So what we have at the root of the Constitution, whether one is an originalist or not, but at the root of the American ethos is this idea that we are not a secular state. God is so important. The morality that flows from religion is so important that the state can't get in the way or impede it. But we understand that there is no society, there is no justice, there is no decency without a fundamental belief in God and an obedience to God that transcends all obligations to the state. And in this is not all that different from the classic Judaic approach. Thank you.
For anyone who has any questions, I will ask you to please think through your questions to keep them as succinct and to the point as possible. I'll begin, rabbis, if you could perhaps, let's back up a step. We're talking about separating the state from the religion and synagogue and so on. Can you perhaps give us some parameters that what is the hard definition of what is a state issue versus what is a, quote, religious issue, and where we in the United States draw the bright yellow line that separates out the two, where there appears to be overlap?
I think the one very clear demarcating line is in the area of religious ritual, that the practice of a religion is defined very much in terms of the special rituals that pertain to that religion. That could be prayer service. It could be, in the case of Judaism, the observance of Shabbat, the observance of kosher laws, the ability to perform a circumcision without interference from the state. And I think there always has been a very strong constitutional tradition that a part of what free exercise of religion means, and leaving alone every single individual to practice their own religion, is the ability of people to be able to perform their own religious rituals without any kind of interference. And in fact, this tradition is found very much in the Jewish legal sources as well, in terms of the absolutely sacrosanct nature of the priesthood, of those who were entrusted with the performance of the religious ritual in the Holy Temple, the Kohanim, that it was very clear that there was a two-way separation. Nachmanides, the Ramban, writes in his commentary to the Torah that there was a special prohibition against those in the priestly class assuming any kind of sovereign position in the government, because they had to remain absolutely pristine. At the same time, the temple itself was not allowed to have the interference of the monarchy. There was a very peculiar type of gerrymandering that was done in terms of the districting of the Holy Temple, that the area of the altar belonged to the tribe of Binyamin, which was in charge of the holy places, in charge of the ritual places of Jerusalem, of the area of the Holy Temple. And there were portions of Jerusalem that belonged to the tribe of Yehuda, of Judah, which was in charge of the monarchy. And the portion of Judah went almost up until the very location of the holy altar in the temple. And in fact, there was the southeastern corner of the altar actually was in the portion of Judah. But because it belonged to the portion of Judah, there was no base on the southeast portion of the altar, so that there would be no part of the altar that would have in any way the mark or the presence or the influence of the monarchy upon the performance of a ritual worship that was done in the Holy Temple area. And this just underscored the recognition that Jewish law and the Jewish tradition has always had for the importance of keeping the sphere of religious worship distinct and protected from the interference of the government.
And going forward to the Jewish experience in the diaspora, since ultimately, as we know, everything, including monetary and civil law in Judaism, is the law of the Torah, relates to our obligation to God, the obedience of Jews to the law of the land and giving precedence to it actually comes from the Torah itself, where we establish in Tractate Bava Kama on both sides of page 113 Shmuel says that the law of the land is the law, which is a powerfully profound statement. The law of the land, and we'll fill it with regards to blank, we'll fill in the blank in a moment, is the law of the Torah. So first of all, to any just, which means to say you don't discriminate against people arbitrarily on the basis of religion, race, and so on, you don't have to like the tax rate, but any just, non-discriminatory form of taxation is absolutely the law of the land, which means that it's the same obligation in a sense that you have to shake a lulav, you have to file an honest IRS return. And it becomes the law of the Torah. But the general consensus in Jewish law, and Rabbi Rees can correct me, is that all monetary and civil law comes under the rule, the law of the land is the law. That's on one hand. On the other hand, we say that no one has the right to interfere with our observance of Judaism outside those places where the Torah itself tells us that the law of the land is the law, because our obligation is directly to God. As, again, even James Madison, or I shouldn't say even, but certainly as Madison and Locke and the thinkers who founded this country, who, by the way, are coming from a very different place than the thinkers that sourced the French Revolution, hence the continental obsession with secularism and our obsession with freedom of religion. But on the other hand, if we look within the American system, within Supreme Court decisions, we see an arc dealing with a similar question. In other words, if we say, look, you can't interfere with kosher or circumcision or the Brit and so on, the Supreme Court has been very good at limiting itself. It argues that where there's a compelling public interest, it can stop a religious behavior. In Massachusetts, a child was taken away from the jurisdiction of its parents because they refused to give it surgery that would have saved its life, that it would have died without. And if we look at the arc between the Peyote case, where the Supreme Court ruled against Native Americans using a hallucinogen in their religious behavior, because the Supreme Court at the time believed that this use of a narcotic was dangerous and was against the compelling public interest of the safety and health of the country as a whole. Whether you agree with it or not, that was their decision. There was a compelling public interest. On the other hand, the town of Hialeah, famed for its dog tracks in southern Florida, there was a Cuban religion that sacrifices chickens and the like, and there's a law against slaughtering animals within the city limits, chickens, goats, and so on. And the Supreme Court ruled that there's no compelling public interest, there's no great danger to the public, and therefore the laws must fall away in the face of the determination of people to keep their religion. So there's a certain two-step dance between where we let the law in and fortuitously where the law of the land, where the Supreme Court says, hey, we're going to let people practice their religion.
Again, if anybody has a question. Okay, so just quickly to summarize so everyone can hear, the question is about the second sentence that's up on the board there. Is the duty of every man to render to the Creator such homage and such only as he believes to be acceptable to him. We ask for a little clarity about that quote, please.
So it's absolutely the case that one of the things that was taking place before the American Revolution, there was a time of enormous religious ferment. There were tons of various small churches and the like floating around. There weren't all that many Jews yet, and they were basically divided into, well, they were all Sephardic. There might have been one small Ashkenazi community in New York. But the point is that, yes, that's exactly what Madison means. In other words, in the United Kingdom, first they recognized Catholics, then they recognized Jews, and later they recognized Muslims to have schools and so on, because in England, the state recognizes each religion separately and provides them with funding for their day schools and so on and so forth. In the United States, everyone's right to worship is absolutely free. And yes, we give no credence to a church of one more than a church of 1,000. That's the basic premise. Everyone gets to do their thing, and as long as it's not against the compelling interest, we get out of their way. There were attempts to establish churches in the early years between the Revolution and the Constitution. And this letter and Jefferson's letter, in a slightly different context, were written to negate that possibility.
So, I'm a little intimidated answering these types of constitutional jurisprudence questions with Professor Lewin in the audience. But just to kind of spell out from a more Jewish perspective, I think that as from an American perspective, what our concern is that when there is a legitimate religion, however defined, that the religion be able to practice its precepts without interference and with a sense of respect and tolerance from the government. And in that respect, once there is such a religion, then if an individual is acting according to their religious precepts, as long as it can be demonstrated that they're acting in accordance with their legitimate individual conscience, and that they feel that what they're doing is reasonably required by their religion, then this requires a certain amount of deference. I'll give you an example. There was a tort case, a very interesting case of a girl who was on a date, and she was on a ski lift. This is a New York case, and the fellow she was with somehow wasn't paying attention to the time. He was a typical young Jewish fellow, yeshiva guy, and didn't realize that it was closing time. And they ended up being stuck on the lift when the outfit closed for the night. And she felt that here she was sitting next to a young fellow, and it was dark, and there was nobody else around. So there was a yichud prohibition. She wasn't allowed to be alone with a fellow. So she jumped off. And as a result of jumping off, she suffered facial lacerations when she fell into the bushes below. And when she brought a tort action against this resort for closing and not noticing that there was a date, a shidduch date, on the ski lift, the argument against her was that Jewish law authorities could be found who would conclude that she had no obligation to jump from the ski lift, that it wasn't necessary for her to jeopardize her life simply because she was sitting next to this fellow. The truth is that the matter is not without dispute, but such authorities could in fact be marshaled. But the court concluded that it wasn't their job to delve into religious doctrine and to determine whether she was correct or incorrect as a matter of Jewish law. What counted was that she legitimately felt that her religious tradition required this act from her, and therefore that's something which should be respected. So I think that the more pertinent question is whether a person who is part of a legitimate religious group is acting in accordance with the dictates of their conscience. I would also point out that there's one distinction that I have gleaned between the writings of Locke and the writings of Madison, that Locke's primary emphasis was on the ability of each individual to follow the dictates of their conscience, and that all separation of religion and state was precisely for this purpose of providing for the personal religious freedom of each individual, while Madison actually said religion and government will both exist in greater purity the less they are mixed together. From Madison's perspective, there was also a concomitant benefit for the government as well to remain untouched by religion.
Essentially, the law of the land is the law with regards to a range of monetary, civil, and societal obligations. Where the law of the land contradicts the law of the Torah, so for example, where we have an obligation to all human beings, but especially to our fellow Jews, so where the law needed to be broken in order to get Jews into Switzerland, that involved forbidden money transfers because of the War Powers Act, or whichever the particular act was that stopped money transfers to allies of the Axis. Where other actions might have been taken, where during the British Mandate, the law of the British Mandate was violated to get Jews into the land of Israel, where was the only place they could find refuge, and so on. So the Torah law always trumps the law of the land where they contradict. And I'd like to turn it over to Rabbi Rees.
The principle of Dina de Malchus Dina, that the law of the land is the law, is not a completely absolute principle, as Rabbi Yaffe has indicated. Even in the monetary realm, it's not intended to take away authority of the independent Jewish courts from deciding cases according to Jewish monetary law. In fact, I serve as a judge on a rabbinical court here in Chicago, the Chicago Rabbinical Council, and we routinely decide cases according to Jewish monetary law. It really applies primarily in the sphere of taxation and in the sphere of general economic regulations that are of extreme importance to the betterment of society, such as bankruptcy laws or rent control laws. If two partners in a business have a dispute, or two neighbors have a dispute, or two individuals have a contractual dispute, the government doesn't care, generally speaking, if two individuals negotiate a private arrangement and resolution between themselves or agree to conduct themselves according to Jewish law. In those situations, a Jewish law would still be applicable, and that really pertains to most monetary situations and to most monetary disputes. Of course, if a Jew is involved in a transaction with a non-Jewish person who's bound or who conducts himself or herself according to the monetary laws of the land, and the Jew is bound in that transaction by the same laws as well. But whenever you're in the ritual sphere, when it comes to something like keeping Shabbos or keeping kosher, then a Jewish individual, as a matter of Jewish law, would be duty-bound to conduct himself or herself according to the ritual law, even if the law of the land prohibits following and observing the ritual law. So if there would be a law, and this would occur in oppressive countries over the centuries, saying that the Jews can't observe Shabbos, it would be obligatory for a Jew to keep Shabbos anyway, unless there would be danger to the individual's life. And if there was a prohibition against observing a positive commandment, such as wearing tefillin or wearing tzitzis or something of that sort, then there's also an obligation to keep the commandment anyway, at least up until the point where the person does not lose 20% of their overall fortune. So there are different rules and different gradations based on the severity of the offense. This came to the fore a number of years ago when there was a law in New York that established a clergy penitent privilege, that any communication with a rabbi or other clergy person was considered to be privileged. And there was a case where there were rabbis in Long Island, in New York, who were privy to information that was shared to them by a husband in a divorce dispute, and based on the information, that was shared by the wife, and based on information that the wife shared with the rabbis, they felt that they were obligated to divulge some of the information to the husband, some of the information to the court, to guide the court in terms of the custody dispute between the parties, because as a matter of Jewish law, they felt that she had communicated information that they needed to divulge in order to protect others against spiritual harm, which is a Jewish law commandment of not standing idly by your brother's blood, which means even your brother's spiritual blood that is oozing out of their soul. And the lower court judge ruled that the rabbis, the wife in that case, sued the rabbis for a breach of confidentiality, and the lower court judge ruled that the rabbis could be held liable because they violated the statute. And the rabbi said, we had no choice because our religious precepts, at least according to our interpretation thereof, required us to divulge the contents. And a number of Jewish legal authorities and rabbis got up at that time and criticized the lower court ruling and clamored for a reversal of this ruling. And that's an example of taking action. And eventually, the voices were heard, and the highest court in the state of New York struck down the lower court ruling and said that the law on the books is an evidentiary rule. It means that whatever is communicated can't be used as evidence in a trial, but the rabbis themselves have the right, if the dictates of their religious conscience require it, to divulge information if they feel that that is a religious obligation on their part.
Try not to intimidate everybody over there, Mr. Lewin.
Well, I'm very flattered that Rabbi Reese made the remark he did. I walked in just before he did, and I want to confirm, really, and emphasize his response to the question that was asked with an incident, really, which I personally experienced, which was that in the case in which I litigated in the Supreme Court of the United States on the right to wear a yarmulke in the Air Force, the government, very surprisingly, in its briefs, argued in part that this Air Force psychologist had no right to wear the yarmulke or to make a constitutional claim because there was a tshuva of Rav Moshe Feinstein, which they relied upon, which said that in an office, if you need it in order to maintain your livelihood, you could sit without a yarmulke. And they said, this fellow is just kind of exercising his personal preference and not his religious obligation. They surprisingly put it in the brief. The woman who argued the case for the Solicitor General, when she stood up before the Supreme Court, she did not get more than a minute into her argument before Justice Brennan really, very angrily got after her about that proposition and asked whether the government really stands by that. She spent about a minute or a minute and a half hemming and hawing, and then ultimately had to abandon it, because there's no question, as Rabbi Reese said, that the courts say they're not going to go and determine the fact that there may be some people who don't wear a yarmulke and some people who do want to wear a yarmulke. That's not the government's business. It's the individual's religious obligation that controls. So then the question is, how do you draw a distinction between what is a legitimate religious rule and simply a sham, something that's a total make-believe, created religious obligation? Interesting story. After we succeeded in getting the federal prison system to provide kosher meals in federal prisons, and we litigated that for some time, a group in Atlanta Federal Penitentiary, which was very imaginative, formed the Church of the New Song. The Church of the New Song, they said, had the religious obligation of having one meal a day of steak and sherry. And they said they are entitled in prison to get steak and sherry in one meal each day. You may laugh about it, but that bedeviled the federal judiciary. It took a number of visits to the Court of Appeals before they finally decided that they had a right, the trial judge had a right to investigate to see whether this was not a total fraud and a sham, and ultimately the Church of the New Song was rejected. But it demonstrates how deferential the American constitutional and judicial system is to a claim of religious obligation. It's ordinarily given great respect, and the rule is that the courts are not allowed to look behind what appears on its face to be a legitimate religious position.
You mentioned earlier that Jefferson's views were a little different, and I'm just curious if you could talk about that a little.
I think that the question regarding Jefferson is just how binding his statement was when he said that the Constitution built a wall of separation between the church and the state. Not everybody feels that the free exercise clause of the Constitution, coupled with the establishment clause prohibiting Congress from establishing a religion, necessitates a complete separation between religion and state. Some feel that what the purpose of these provisions really is simply to provide individuals the ability to exercise their religion freely, and also to prevent Congress or to prevent even the states, according to the broader interpretation, from establishing a specific religion that will be the official religion of the country or the official religion of the state. But it's the feeling of many jurists, including Justice Scalia, for example, that it was not intended to prevent Congress or to prevent individual states from favoring religion in general over non-religion, that there is a certain respect that the country has for the religious tradition. That's why legislative sessions, for example, begin with a prayer. This practice was even upheld in a recent Supreme Court jurisprudence in the Marsh v. Chambers case, and more recently in the Greece versus Galloway case that was just decided this past year. Those who want to argue that there's no respect for religion in general or preference given to the notion of religious belief in general have a hard time justifying these decisions. They'll say this isn't really part of a preference for religion, it's just part of our begrudging respect for our cultural tradition, which allows these practices, including engraving "In God We Trust" on our currency, but there does appear to be a general recognition of the fact that the American Constitution, that American jurisprudence, is informed by what is sometimes referred to as the Judeo-Christian legal tradition and the respect for religious practice in general. However, at the same time, nobody would argue that the Constitution allows for discrimination against those who choose not to embrace a religious belief at all, but there is certainly a doctrine of accommodation for those who wish to practice religious belief. It's something which I believe that we in the Jewish community should support wholeheartedly, because it enables us to be able to practice our religion freely, something which we certainly have not been able to take for granted over the ages, and it really requires from us as well a vigilance in terms of making sure that the rights of other religions to be able to freely practice in this country are similarly respected.
It's about Mitzitza B'Peh, which is part of the procedure of Bris Milah, and the issue was raised about potential safety hazards, and since there appears within halacha to be some leniency, or at least divergence of opinion, why do we insist on Mitzitza B'Peh? Does that summarize your question accurately?
Yes, sir.
Okay. Well, we're all out of time.
Look, essentially, the question, again, is not whether there are such authorities. The question is, what do the people who insist on practicing Mitzitza B'Peh, what do they believe? Then the question is there a compelling public health interest to nevertheless prohibit? You sometimes have a compelling interest, such as in the peyote case, and the question is, does it exist? And this is really the argument raging at the moment, and I don't think there's anything more to say than the intersection of these two questions. But the idea that there's 42 rabbis, it's the same thing that Mr. Lewin said. It doesn't make a difference what one rabbi says if you believe differently.
Yeah. The Supreme Court jurisprudence allows there to be laws of neutral applicability that just incidentally happen to affect the practice of a religion. It actually even got rid of the compelling interest standard in the peyote case, but it was somewhat resuscitated with the Religious Freedom Restoration Act that was passed by Congress. That's just the semantics. But what one really has to look at when you see these types of attacks on a particular religious practice is, what's the motivation? Is there really a health issue? Is there really a concern which is being spread amongst the entire population? Or is there a certain discomfort or hostility towards a religion that is coming out because there were a couple of incidents that may have been reported that may not have been fully investigated in terms of the totality of the picture, even the details of those particular circumstances? When the legislation is passed, is it being passed in terms of dealing with non-hospital medical procedures in general and procedures that should be followed, or is it really targeted against a particular religion or a particular religious practice? These are some of the questions you have to ask yourself when these issues come to the forefront, and I think you have to be very wary and you have to be very suspicious and you have to really be vigilant in terms of making sure that nothing happens which is going to compromise the freedom to practice religion. When we speak about the integrity of religion and the separation between synagogue and state, we really have a focus upon upholding the holiness of the synagogue, upon upholding the holiness of a religious practice and a religious belief. This is a major issue even in the contemporary state of Israel as well, where there is much more of an overlap between the governmental systems and the religious bodies. And we do see that there sometimes is a real and realistic danger when there is too much entanglement between the two domains. What we really care about is that there be a respect for the religion, there be a sense of holiness that everybody has for the practice of the religion, and there be a sense of a pristine area of worship that can be untouched by any external forces, whether it be from without or whether it be from within. There's a story that the Talmud tells about how when King Yanai was called in front of the Sanhedrin because one of his servants had committed murder, and he was required to appear on behalf of the servant. And the head of the Sanhedrin, Shimon ben Shetach, told King Yanai to stand up and show his deference for the Torah law that governed not only all of his subjects, but King Yanai himself. And King Yanai refused to stand up. He refused to show his deference for Torah law. And the Talmud tells us that because of that refusal, because of his feeling that he was somehow above the law, a terrible tragedy occurred, and many, many sages of the people were killed at that time. If there isn't this respect, if there isn't this recognition from governmental leaders and from other forces for the pristine integrity of the religion, of upholding and of respecting religious law, in our tradition, it has unfortunately always led to catastrophe. One thing that we can learn and one thing that we should learn is that regardless of any individual's personal observance, the institutions of religious belief and the rituals of a religious belief have to be protected as soundly and as vigorously as possible in order to enable us to flourish as a religion and in order to enable the society around us to remain as pure as possible and as committed to the traditions that caused this country to be founded in the first place. I think that is the solemn responsibility that all of us have as Jews and also as citizens of this country.
And taking off from there, the idea that God lies at the center of the morality and the quality of this country is fundamental. In Zorach versus Clausen, the Supreme Court, the majority opinion says that all our institutions presuppose the existence of a supreme being. The case itself is very interesting. Chabad was actually involved obliquely. But going from there, this dovetails with Judaism because we are obliged, as we mentioned earlier, we now have the freedom to sway the whole world, to follow the Noahide laws. And essentially that means that, and the beginning of the Noahide laws is that there is a God who is the source of morality, and many of the accepted premises of morality in this country, indeed, they're in synchronicity with the Noahide laws. But the idea, what we have to be vigilant is to allow anyone to take God out of the central place that it has in our nation and constitution, because in doing so, if there, God forbid, is a secularization, that also takes away the universal moral values that any society is based on, and is a contradiction to our fundamental obligation to our fellow citizens to ensure that they have the opportunity to pursue this morality.